Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It is Saturday, August 20th, so that means one thing. A recap of all the top stories throughout the week, all in one convenient location. Thanks for watching, and we'll see you next time on Crime Talk. Enjoy. Next on the docket, let's talk about Lori Vallow and Chad Daybell. Guess what? The state has filed their objection to the defendant's motion to remand to the grand jury for probable cause determination. As you may recall, the defense wanted aggravating factors to be placed into the elemental instruction, and they cited some case law for it. Now the prosecution has finally filed their response. It's dated August 12th, and they basically say there's no constitutional requirement that the state present evidence demonstrating probable cause for each aggravating circumstances to properly notify the defendants of its intent to seek the death penalty. Now, the issue has to do with the case out of Arizona that said an aggravating factor that increases a punishment has to be charged, presented to a jury, and proven beyond a reasonable doubt. The next argument that the prosecution said was, hey, it's untimely. You should have filed this sooner. But they do concede the fact that, well, defense counsel recently just got on the case, and there was this whole situation of competency. So, Judge, we think you can probably hear the issue in that regard. You have the discretion to do so. So we'll discuss this more tomorrow night when we go live at 6 p.m. Mountain Time on our Tuesday night live show on both YouTube and Facebook. And what is the significance of the argument that the defense and the prosecution are arguing about? This Arizona v. Ring case was a Supreme Court case that said, if you are going to have all these aggravators, you have to prove it because it increases the punishment. And therefore, our founding fathers would have said, you got to charge it, present it to the jury, and prove it beyond a reasonable doubt. Okay? For years, states were saying, let's just charge this person with the death penalty, and we'll just have a three-judge panel decide what to do. Of course, you can't do that. It's got to be presented to the jury. So the defense is really saying, hey, we're unsure what you're doing here in these charging documents, but we think you need to take it back. Now, Idaho apparently has ruled on the case. I will read that case by tomorrow and be able to explain it further if it's really necessary. But the issue then becomes, do you want to create an appellate issue, or do you just go back and say, fine, we'll do whatever you want, and we're still going to convict your client? That's what I think a good prosecutor should do, but we'll talk about it more tomorrow night when I get back from this little road trip. Next, there was a stipulation in the matters regarding the DNA testing of the defendants. So Chad Daybell and Lori Vallow have come to a stipulation where their respective counsels agree and follow regarding the consumptive testing. 1, the parties agree that the samples listed in the state's motion for the consumptive testing may be consumed by the state lab, and they're going to determine if there's a sufficient representative sample. And in the event a sufficient DNA sample is in fact available to create a more than one profile, the DNA sample will be split between the parties for testing, and each party may have the expert of their choice test the respective portions of the DNA. In the event sufficient DNA is available for one profile to be created, the parties agree the state lab shall halt further testing if there isn't enough sample there, and then they will determine at a later time who should conduct any further testing. And fourth, in the event the state lab determines there is not a sufficient DNA sample to create a DNA profile, the parties shall reconvene to determine what, if any, course of action to take. Now, what does that really boil down to? As you may recall, we talked about this. Normally, it's the government's evidence. They can test it when they want. If it's going to be consumed in testing, they have to tell the court. The court says, defense, go coordinate with them. You can watch, you can observe, but it's got to be done. It's unclear why the defense, or the prosecution in this case, is agreeing with the defense and basically doing anything. The state should test it. If there's enough for the defense to sample their own sample, fine, that's great, they get to do it. If there isn't, then the other party should be present and they can test it and they can do what they want. But now this last thing is if they can't agree and there's not enough sample, then they're going to reconvene and decide who does the testing. You know what that spells? One word, ladies and gentlemen, DELAY, delay. If anyone hasn't noticed, we're almost on September, right? September, October, November, December, 4 months until we start a trial. And they're still trying to figure out when the DNA testing is going to be done. Are you kidding me? Get this show on the road. This case is the prosecution's case to lose. And if they want to sit around and play games like this motion should have been filed months and months ago, in my humble opinion.
All right, Lori Vallow went to court today, and she was all smiles, both during and after. That's right. Lori Vallow appeared in court Tuesday with her attorneys, and they argued the language in the grand jury indictment against her needs to be much more clear. Jim Archibald and John Thomas, Lori Vallow's attorneys, believe 2 of the counts listed in the indictment are complicated and will be too confusing to the jury because they include 2 separate allegations according to their filings. And the judge, Judge Boyce, kind of agreed with this. And what had happened is the attorneys for the prosecution, when they did the indictment against Lori Vallow, is that they said that there was a conspiracy to commit murder and the grand theft, which was the money to take from the children from the public benefits from Social Security. And so that's the theft. The defense is saying, hey, this is too complicated for the jury. And the prosecution is saying, well, it's not complicated. And the defense says, well, no, it is complicated because you're basically saying there's kind of 3 different crimes here. You got the conspiracy, you got the murder, and then you have, with an and, not an or, the grand theft. And so where it could get confusing is yes, a conspiracy is an agreement to commit an illegal act, but you have to show an overt act to start the conspiracy. If I'm just sitting around with my buddy and we're saying, hey, you know what? We should rob a bank. That's not a conspiracy. But if I say, hey, you know what? We should rob a bank. You go pull the car around. I'll get the masks and some weapons. We've taken that step to go do something, an overt act. The defense is saying, hey, this could be confusing because, Judge, we're going to have to define all of these elements of the offense. The prosecution says, hey, our standard jury instructions that the Supreme Court has approved says we don't have to do this. I think the judge is a little concerned about the language and how it's written. The question is, and I've mentioned this before, is do they have to go all the way back to the grand jury? Well, if I was the judge, given this a death penalty case, I'd say go back and do that. Do it correctly. But then you have to represent all the evidence to the grand jury to come with that. It's kind of complicated. Or could it just be solved by giving very detailed jury instructions with further clarification? That's probably the clean fix that the court will decide. But I think the court is a little concerned and even commented, I've never seen it charged this way. And, we'll go from there. And the prosecution also argued that, hey, Judge, this was filed late and you shouldn't even consider it. However, just as expected, the court said, you know what, given the complexity and nature of this case and the discretion that he has under 12B as it relates to the timing of the filing of motions, he found good cause. The court did not take up the motion regarding the consumptive DNA testing because of the stipulation that we talked about the other day. You can go back and look at that video if you want more explanation. Basically, everybody agrees to what they could have agreed to about 6 months ago, so this could have been done and completed because, as I mentioned in that video, there's only 4 months until trial. Just saying. Equals delay. There's no way they're going to get it done. The other motion that was not brought up by the court was the motion filed by Lori Hellis, who had filed a motion to intervene, saying that she thinks the court is not following the appropriate procedure when sealing court records and conducting sealed court hearings, and that the court should not do that any further. No word on when that motion will be held. Now, Chad Daybell and his attorney, John Pryor, did not attend the hearing. They, along with Lori's attorneys, were originally set to discuss a motion about the DNA, but as I stated, they reached that agreement. Next, the Murdaugh saga continues. Now, Murdaugh is the focus of no fewer than 6 separate state criminal inquiries, including the double homicide, a financial crimes investigation, one that's already nested quite a few charges, 83 to be exact, a drug trafficking inquiry, an obstruction of justice probe, and investigation of a bizarre roadside shooting that took place last Labor Day. And there are also 2 other homicide investigations that allegedly have ties to the Murdaugh family and a public corruption probe linked to all of this. Oh, and don't forget the feds are probably looking at him as well. Well, the evidence against Mr. Murdaugh is in the double homicide case is said to be quite extensive and some prosecutors say overwhelming. But they were unable to let the public know what was going to take place because at Murdaugh's bond hearing, where the prosecution was going to lay out everything that took place and the planning that was involved, but Mr. Murdaugh's attorneys agreed that they were not going to contest bond because he was already in custody on a bond that he couldn't afford, so it really would have been academic. And needless to say, the prosecution wasn't able to lay out their case for us, the public. We'll have to wait and see. But the prosecutor did state that the evidence in this case is substantial, and it all comes back to Alex Murdaugh. And, well, guess what? The state has stated that they have turned over all of the evidence that they have in the Murdaugh double homicide, where Mr. Murdaugh is accused of killing his wife and son. We'll see, since there's not a gag order on that evidence, if perhaps it will make its way to the public, perhaps the press. You know, I'm not saying, but if anybody has a copy of it, if they want to Dropbox it and send it to me, I'll be more than happy to take a look at it. It's safe with me. I promise not to share it with anybody on YouTube. Well, maybe. But you can send it to me. We'll take a look at it. We'll evaluate it. In other Murdaugh news, remember Russell Laffitte? He's the banker. Well, he's been indicted on new fraud charges related to his alleged role in the financial crimes component of this sprawling, multifaceted criminal case. Now, Laffitte, who was fired from his position as the chief executive officer of Palmetto State Bank back in January, was previously hit with a 5-count federal indictment, the first criminal charges to be filed in connection with the federal component of the ongoing investigation with the Murdaughs. Those indictments were handed down on July 20th of this year, the same day Laffitte's alleged co-conspirator Alex Murdaugh appeared in Colleton County and pled not guilty to 2 murder charges. The original 5-count indictment against Laffitte included charges of bank fraud, wire fraud, misapplication of bank funds, and conspiracy to commit bank fraud and wire fraud. Now, Laffitte is also staring down multiple criminal conspiracy charges at the state level in connection with his alleged role in the Murdaugh-related financial crimes investigation, which is why reportedly Mr. Laffitte is rocking matching ankle monitors. The latest federal indictment handed down Wednesday alleges that on or about February 20th, 2015, Laffitte, being an officer, director, agent, and employee of the Palmetto State Bank, a financial institution insured by the FDIC with the intent to injure and defraud Palmetto State Bank, willfully misapplied, abstracted, and purloined money, funds, and credits entrusted to the custody and care of the Palmetto State Bank. Specifically, it's alleged that Laffitte caused Palmetto State Bank to fund a $500,000 line of credit to a bank customer for farming, and thereafter issued a $284,787.52 cashier's check, knowing the loan proceeds would be and were used for other purposes, namely to pay off loans previously extended from HP's conservatorship account. This is apparently in reference to the conservatorship of Hannah Plyer, one of the alleged victims of the Murdaugh-related financial fleecings. It would appear down there in the low country of South Carolina, and I mean the low country, which is along the coast by the coastal barrier islands, everybody appeared to be getting a piece of the action, which is why it appears this corruption may have been going on for so long with so many involved, because everyone seemed to think that they were never going to have any problems. Guess that's what happens when your family has run the prosecutor's office for over 80 years. Everyone starts to believe that they become untouchable. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
As you may recall, Lori Hellis, who was on our show, we had her on our show. We talked about the motions that she filed in the Lori Vallow, Chad Daybell matter, because she was really concerned that everything was being sealed and not being released to the public. And normally in criminal cases, things are released to the public. Yes, we're not going to get the discovery, but it seems like everything in the Lori Vallow case and Chad Daybell case, is just about, it's all sealed. Everything is in private and you can't get access to it. And that is very, very unusual. So Lori Hellis, who is a retired attorney, filed 3 motions with the court. The first one was a motion to intervene, a motion for injunctive relief, and a motion to unseal all documents and transcripts for the recordings and hearings. Now, Judge Boyce, in a very, I wouldn't say condescending, but basically says, if you only knew how our rules here in Idaho, Ms. Hellis, you would know that you can't do this. I took it as kind of condescending. But it says the record indicates that Hellis is pro se. In Idaho, pro se litigants are held to the same standard as attorneys. Duh, everybody knows that. So then the judge jumps to the motion to intervene. Hellis cites to the Idaho Rules of Civil Procedure 24 and Idaho Court Administrative Rule 32 as authority to intervene in a criminal case. In addition, Hellis claims standing due to her status as a media member and credentialed author. As more fully explained, the court finds the motion both procedurally and substantively improper. Now, interveners may occur in civil, not criminal proceedings, as indicated by both the absence of a corresponding criminal intervention rule and as determined by Idaho case law. Now, remember, ladies and gentlemen, the public has a right to know, and the press can file something with the court saying, please, we want to record these proceedings. Ms. Hellis files a very well-written, I thought very well-reasoned analysis as to why she, as a member of the public, should be allowed to see these documents and saying, hey, Judge, I want to formally intervene. Look at me over here. The court says, we don't even have that in criminal proceedings. I get that. That's true. That's the way it is in most criminal proceedings. But guess what? When the rules are silent on the rules of criminal procedure, then you look to the rules of civil procedure. Then you look to the rules of civil procedure for guidance. And that's what Lori Hellis did. But the judge basically said there's no mechanism for non-parties to intervene in criminal cases. And therefore, the motion is denied. The court then goes on and addresses the issues made under Rule 32 and basically says, once again, denied. The court finds Hellis' request as pled fails to honor many of the policies set forth in Rule 32, which includes providing express procedures for the public to obtain court records that makes the most effective use of the court and the clerk's staff and avoids unduly burdening and ongoing business of the judiciary. And Rule 32 does not permit interveners in this case, and for that additional reason, the motion to intervene is therefore denied. I mean, I just think the tone, very condescending here by Judge Boyce, but that's just me. That's just the way I read it here. And then the final motion for injunctive release. The second motion, Hellis' second motion for injunctive release says that Hellis' second motion is a motion for injunctive relief. The court first notes that even if Hellas were a party in this case, a demonstration of standing is a prerequisite for obtaining any such release. In order to have standing to seek injunctive relief, a plaintiff must demonstrate a likelihood of repeated injury or future harm to the plaintiff in the absence of the injunction. Then once again, he says, but she's just an intervener, and in this motion sets forth the above has no right to intervene in the criminal case. And so can you imagine what the court says? Yes, that motion is denied. The court then goes on to state regarding the unsealing of records that says that on August 6th of 2021, the court entered a public order in this case directing that all subsequent pleadings in the case be filed, captioning only the individual defendant's respective case number and name. While the order is expressly directed to counsel, the intention of the court extends to any person attempting to file pleadings in either case contemplated in this order in order to maintain a consistent, orderly administration of the case. However, should Hellas desire, she may comply with the order as well as the Idaho Court Rules 2.3A4 and refile the motion or motions requesting the unsealing of records, at which time they will be considered by the court. If refiled, the court directs Hellas to identify which specific records, transcripts, or hearings are requested to be unsealed as they relate to each distinct case. Further, upon refiling a separate motion, the court will thereafter designate interested parties in each individual case. See Idaho Court Rules 32.1I1. Upon the court's designation of interested parties, Hellas must thereafter provide proper notice to all interested parties pursuant to the rules. Upon certification that proper notice has been provided, the court will and then schedule a hearing and request the unsealing of records in accordance with the rule and in order to satisfy due process and allow all designated interested parties an opportunity to respond to the request. Therefore, motion to intervene, denied. The motion for injunctive relief, denied. And Hellas's motion to unseal, denied. But that's without prejudice. She can try again if she could get her captioning down correctly. Are you kidding me? This is a classic example of form over substance. Okay, Judge, you're not going to allow her to intervene. You're not going to grant her injunctive relief from having the next hearings sealed. But now, if you could get it possibly correct and you dot your I's and cross all your T's, then maybe we'll have a hearing if proper notice is given. And if you let me know exactly what you're looking for, then we can help. Well, hey, Lori Hellas, let's chat. Let's see what we can do. Let's see if we can coordinate this. We want it all, okay? We want it all. I'm telling you, this is why people don't trust the government. This is public information. These are public records. And when the public has to fight to get copies of what they are entitled to do under their own rules, then they create all these little rules that you have to jump through hoops backwards with bells on just to see if you can actually make your way through the legal maze. And you wonder why people don't have trust in the system. Really, Judge? Form over substance. That's what that order is all about. Doesn't say you're not entitled to the stuff. Just says, the way you went about it just isn't right. So therefore, come back and try again, you little peasant, Miss Lori Hellas. Come back and try again. Unbelievable. Next on the docket, that's how he likes his Drano in the morning. A California dermatologist is accused of poisoning her husband with Drano and causing him serious injuries and has been issued a restraining order against the doctor and the two children. Now, Yu, 45, also known as Emily, was allegedly caught on camera pouring the drain cleaner into her husband's Jack Chen's drink in newly released footage by Chen's attorney. Now, Chen brought police in the city of Irvine photos of Yu supposedly pouring the Drano into his lemonade at their little mansion that they have. She was arrested on August 4th after he accused her of doing it on 3 separate occasions. She was released a day later after she posted $30,000 in bond. Her husband has since filed for divorce and asked a judge for a restraining order. The judge granted the order, and Yu is now required to stay away from the couple's 2 children, ages 7 and 8. Now, attorney David Wohl says his client is being set up. The idea that my client, who is 45 years old, well respected, a dermatologist in Orange County, would destroy her life, destroy her children's lives, and try to kill her husband is just completely absurd and untrue, and for that matter, defamatory. Stephen Hittleman, a lawyer for Chen, says that his client has suffered swelling in his esophagus and stomach ulcers from drinking the alleged spiked lemonade, and spent weeks wondering what was causing him to get so sick. They have since presented footage from a hidden camera in the kitchen they say shows you holding a bottle of Drano and pouring it into the lemonade. Now, Wohl maintains Yu used the cleaner for its intended purpose. Anytime she poured Drano into a cup, it was completely empty. It was for facilitating use in the sink or any other part of the house that was clogged as far as the drainage goes. But she never poured any Drano or any chemical into any drink that father or her husband used or was drinking ever. That's completely untrue. He calls Chen's desperate to both divorce Yu and gain custody of their 2 children. He continued that we believe completely that these claims he made are all part and parcel of that effort, Mr. Wohl added. Now, Hittleman has disputed Wohl's account of what happened. Obviously, they're in court. Now, while screenshots of the alleged hidden camera have been made available, the actual video footage has not yet been released. And when it does, we'll bring it to you so that you can decide what is happening in that particular case. Trying to poison him or just, cleaning up around the house? Because I know I use Drano to clean out all my glasses as well.